So now we're going to move on forward with our presentation. We have Katie Wutchiett, who leads the implementation of legal aid at Work's medical legal partnership with WIC and home visiting programs in Contra Costa County. She provides legal advice and representation, technical support, and community education regarding workplace rights for those struggling with family and medical crises. She's trained hundreds of healthcare and service providers and has provided legal representation to dozens of low-wage, frequently immigrant workers throughout state investigations, mediations, and litigations. And along with Katie today, we have Sharon Tiermann. She's the Director of Work and Family Programs and Senior Staff Attorney. She provides legal advice to workers in low-wage jobs also, and represents employees facing family medical crises, advocates for policy change to promote family-friendly workplaces. She educates the community through trainings, know your rights materials, and technical assistance. She's an expert on family and medical leave policies and has helped craft several landmark laws improving California's work-family policies, including expansions of paid family leave to cover caregiving for siblings, grandparents, grandchildren, and parents-in-law, and increasing the benefit amount, especially for low-wage workers, expansion of job protection leave to millions more Californians, and law providing continued health insurance benefits during pregnancy leave, and a law ensuring job-protected time off to visit or enroll children in school or childcare or to address a childcare emergency. You are heroes, in my opinion, both of you. Thank you so much for all the work you do on behalf of families and young children. We're so appreciative of you being here today, and thank you so much for presenting for our participants. Thank you.
Thank you so much for the kind words. We're always so happy to partner with you and your organization, because you do such a great job of facilitating wonderful trainings, bringing together people who have an interest in the issues, and it's always something that we're happy to be a part of. So as Beth said, we are here to provide a training on the workplace rights of pregnant workers, new parents, and caregivers. So just to kind of get started, I'm hoping everybody can add into the chat a word or two about how you're feeling this morning. It's a Friday, it's the summer. Feel free to throw in a few words. How are you feeling, Sharon? What's your words?
Excited to be here today. It's more than just one word, but how are you feeling, Katie?
Yeah, I'm grateful to be here with everybody. All right, seeing some good happy words too. Someone got good sleep, which is, I think, pretty much everything. Appreciative, overwhelmed. This is definitely a time for that. Happy it's Friday, excited, funky Friday. I like it. Good alliteration. Thanks, everybody. Happy and loved. Oh, that's a good one. I'm glad that people are feeling that way. So to give you a little bit more background on our organization, Legal Aid at Work is a nonprofit founded about 100 years ago, and our focus is just representing low-wage workers in making sure that they have workplaces that are safe and healthy, and where people are free from discrimination. And Sharon and my team specifically, we focus on the rights of workers to be able to take care of themselves and take care of their family members without having to sacrifice their jobs or their income. So looking at the rights of workers who are pregnant or caregiving for family members or experiencing domestic violence or their own serious health conditions. And as far as how we do that, there's a variety of strategies. So we know that, first of all, it's important to have legal protections that are worth enforcing. So we work on a policy level to try to pass new protections, and we'll be covering some of those newer protections today to make sure that people have the right to take this time off and to be there for family. And then on top of that, we help people to access these rights. So one of the things that we have is a free helpline where folks can call if they have questions about their own circumstances or if they're working with a family and they have questions on behalf of a patient or a family about, how can they take time off? How long should it be? How can they get paid during that time? Or if they're having difficulty communicating with their employer about that, getting pushback, or having a hard time getting wage replacement during that time. And then beyond that, where situations are complicated and people are interested and they think it would be helpful, we help provide strategies for communicating with employers. Sometimes we communicate to people's employers on their behalf. Sometimes we file lawsuits, but it's all based on that individual's need and what they know they need in those circumstances and would be helpful for them and those that they're supporting. So as a part of it too, obviously we provide training. So we've worked with different community groups as well as different healthcare providers. So if at the end of this, you're like, this was great, but I think there's other people who should know this as well, feel free to reach out and we're always happy to provide trainings. Here's an example of just kind of some of the things that we've done. So in one of these pictures, it shows a group of folks asking for better protections at the state level. We have a pretty active Instagram presence now, sharing information about workers' rights. And so here's one for Father's Day, highlighting how fathers and parents, besides the one who's pregnant, also have the rights to time off and how that can be important for them to be there with a new child. And that's something we'll talk about more too. And then one of these is highlighting one of our clients, Sharon Easton, who we met at a WIC office in San Pablo, who her employer wouldn't let her pump at work, and we helped her work through that situation. So those are just some of the examples of how we spend our time at Legal Aid at Work. And with that, I'm going to pass it over to Sharon.
Thanks, Katie, and thanks everyone for being here and for having us. It's so wonderful to be with you. Before we jump into the kind of going over what these rights are, we wanted to just spend a minute talking about why this matters. And I think we all know from our own lived experience and from our experience working with families and also from a wide body of research, just how vital these benefits are for our health and our well-being and our economic security. So in terms of, the family benefits, these rights, having the right to take leave with pay and having the right to accommodations and flexibility at work helps people keep their jobs and their income and helps them stay afloat financially. We've seen this especially over the past year and a half, right, with COVID, just that, paid leave is really vital for allowing people to stay healthy. It saves lives, and it also helps keep people in the workforce. And we know that inequities in access to these benefits have led to really egregious disparities in who's been pushed out of the workforce, largely women of color. We know also that access to paid leave is really important for gender equity and allows parents of all genders to play a meaningful role in their children's lives, and that has lifelong benefits for both parents and children. Maternal health-wise, we know this is really critical. There's lots of research showing that access to leave and accommodations decreases maternal depression, stress, and anxiety. And it's important for children's health and for their brain development and lifelong learning. So, reduces preterm delivery, low birth weight, and increases access to breastfeeding, which, as you all know, comes with a host of other benefits. Moving on to the next slide. So yeah, just getting into what we're going to talk about today. We're going to talk about a few different categories of workplace rights. The first one that we'll talk about is access to job protected time off. Yes, I believe this slide presentation will be shared. Thank you for your question. And we meant to say, feel free to just add questions to the chat as we go. We also hope to have time at the end, but as you have questions, please just go ahead and ask them. So yeah, job protected time off work, meaning, do you have the time, do you have the right to take the leave from your job and know that you'll have a job to come back to after the leave? Then there's rights to getting paid while you're off work, protections against discrimination in the workplace based on protected categories like being pregnant, for example, and then the right to accommodations. So changes to the way that you do your work, or sometimes where you do your work, for both pregnancy and breastfeeding. And thank you to all of you who filled out the pre-training survey. We saw that when asked on a scale from 1 to 5, how confident you feel in your ability to advise families about workplace rights, the average response was 2.9. So it sounds like folks have some foundation, but are excited to learn more. And so the things that people said they were hoping to learn today were new rights, how to empower and advise families that you work with, resources and referrals, where to send people who need more information, and everything. So I don't know that we'll be able to cover everything, but we will do our very best to get into some helpful summaries of the key rights, and we'll certainly point you to where you can go for more information.
Thanks, Sharon. And as Sharon mentioned, feel free to type questions into the chat. If we don't respond to them in the moment, it might be because we're going to be talking about that in a few slides, but we can definitely come back to everything and appreciate that engagement throughout it. And so the first right that I want to talk about with you all is pregnancy, the right to be free from pregnancy discrimination. So employers are not allowed to discriminate against workers who are pregnant. And I think, that's one that many of us know, but it's important to think about the different ways that it applies. So that means it includes hiring. Employers aren't allowed to choose not to hire somebody because they're pregnant. It also comes to terminating people, providing pay and benefits, promotions or demotions during that time. And a really important part of it is it means that employers are not allowed to force somebody onto leave. I think pretty often we hear from people whose employers say, okay, you're pregnant, you need to put your feet up, you need to take some time off from work. But that's not for the employer to choose. That's up to the worker to know their own health and what they need. So employers are not allowed to force somebody onto leave just because of the fact that they are pregnant. And as a part of it, employers are also not allowed to create a hostile work environment. So we hear from folks who have employers that talk about how it's inconvenient that they're pregnant, or asking invasive questions about their pregnancy. But folks have the right to keep working and to have it be a safe and respectful place. So that's another thing that employers aren't allowed to do, to make it a really hostile and difficult place to work just because somebody's pregnant. Moving on to the second category that Sharon mentioned at the top. In California, we're really lucky that workers have the right to accommodations for their pregnancy. And what that means is changes to the way that they do their work for the benefit of their health. And this protection, it applies to all employees who have an employer with at least 5 employees. So that means that they can work part-time, they can have started their job yesterday. That doesn't make a difference. If they are an employee and their employer has at least 5 workers, they have the right to accommodations. But one thing to keep in mind is that to trigger this responsibility of the employer to provide accommodations, they can require somebody to provide a medical note from a healthcare provider. So saying that, because person is pregnant, she needs to be able to sit during work rather than stand, or, she needs more frequent breaks throughout the day. And we always suggest that if somebody's pregnant, they just have a real conversation with their healthcare provider about what their work looks like. because there's no one set of accommodations. It just depends on what's comfortable or uncomfortable or difficult for that person. So somebody who's working in a pizza kitchen might need very different changes from somebody who's working at an administrative desk or working at their computer, whether it's comfortable shoes or breaks. It just depends on what that person needs. But one tip that we want to be sure to share is that in asking for these accommodations, it's important to be specific and to start asking for smaller things rather than larger changes. And the reason for that is that employers are required to give their employees these changes or accommodations unless it's something that would not allow the person to perform their job. So if it's a case where the person would not be able to perform their work, the employer has to look and see, okay, do we have other positions available? Is there something this employee can do? And if there isn't, there are circumstances where they can put the employee onto leave. And Sharon will talk a little bit more about leave in a few minutes. So for example, if somebody's job is delivering packages and, literally all of the packages that they deliver are 20 pounds, every single one, there's no way that they can deliver these if they can't lift 20 pounds. If their healthcare provider gives them a note that says, okay, they can't lift over 10 pounds, if their job, literally consists entirely of lifting 20-pound packages, then the employer would have an obligation to look and see, okay, is there a desk job? Is there an alternate route? Is there like a way we can change the deliveries? But if there isn't, they would be able to tell that person, okay, you need to go onto a medical leave at this time. So that's a reason that it can just be really important to be specific and think about that specific workplace. Because if the restriction is more significant than it needs to be, that can narrow off different jobs that person might actually be able to perform. So it's always good to have that as a real conversation. And so with that, I'm going to pass it back to Sharon to talk more about pregnancy workplace rights.
Thanks, Katie. So I'm going to jump into talking about leave from work. And this is an area that is a little bit complex and can be confusing for folks. And so we like to start by explaining that there's actually two different concepts when we talk about leave from work. And one is the right to take the time with job protection, knowing your job is secure, but not necessarily, the pay doesn't necessarily come from that right to job protection. And then the separate right is where do you get paid? Where do you get your money while you're off work? And that we call wage replacement. And so the thing to keep in mind is, of course, people want both of these things, but we have to really think about how they kind of line up with each other because they derive from different laws and different programs and often require different processes that the worker has to follow. So we will go over those concepts in a little bit more detail. And even beyond the distinction between job protected time off and wage replacement, there's different kind of like categories or reasons for the leave, right? And so the first category is time off that we'll talk about is time off when the employee herself or himself, the employee is pregnant. And this is for the person who is going to be delivering a baby. And so that is for pregnant, it's called pregnancy disability leave, but it actually covers the disability, the time that the person can't work leading up to the childbirth and for recovery from childbirth. And then we will talk about, even once the person has recovered from childbirth, the right to take time to bond with the child. And of course, we're bonding with the child as soon as the child arrives, but the law distinguishes between recovery for the person who's delivered and bonding. And that actually serves to give that person who's had a child, who's delivered the child, more time because they get a chunk of time while they're leading up to the childbirth and recovering. And then once they recover, they get more time to bond. And so the first law I want to talk about is a job protection law, and this is California's Pregnancy Disability Leave Law, or PDL. And this is a law that's actually been on the books in California for decades, and it provides up to 4 months of job-protected leave while a pregnant person is disabled by pregnancy, childbirth, or a related condition. It's important to note that when this law uses the word disabled, but even folks who have a normal pregnancy and uncomplicated childbirth will be entitled to take job-protected leave for their pregnancy and recovery from childbirth. Typically, the period of time that someone with a normal uncomplicated pregnancy and childbirth will be able to take under this law is starting at 36 weeks of pregnancy or 4 weeks before the due date, through 6 weeks postpartum for a vaginal delivery, or 8 weeks postpartum for a C-section. So that is fairly standard, but you do have the right to up to 4 months under this law if, for example, you have complications or you need to go in bed rest earlier in your pregnancy, or if you have postpartum health issues, postpartum depression, you can extend your leave beyond the traditional period of recovery up to the 4 months. This law is very broad in terms of who is covered. It's the same requirements that Katie mentioned for the accommodation law, which is that you just have to work for an employer with 5 or more employees. There's no tenure requirement, there's no hours requirement. So all pregnant people are entitled to this leave with job protection. It doesn't require that your employer pay you. We'll talk in a minute about options for pay, but it does require your employer to give you the leave and give you your job back after the leave. It also can be used intermittently. So for example, if you need to use it for prenatal care or you wake up one morning with morning sickness, this law will cover your job for those intermittent instances of leave. And it includes continuation of health insurance coverage. So if you're someone who gets health insurance at your job, then your employer must continue your health insurance benefits under the same terms and conditions while you're on leave as if you were not on leave. And so we talked about the job protection law. So how do you get paid while you're on pregnancy disability leave? Well, for folks who pay into the state disability insurance program, that is how they get paid. Now, this is partial pay. It is partial wage replacement while you're unable to work due to non-workplace related disability or injury, including pregnancy and childbirth. The eligibility requirement is really that you've just paid in to the state disability insurance fund, and you would know that by looking at your pay stub. It should have a little deduction taken every pay period that shows you're contributing to, it might say CA, SDI, or SDI. And virtually most private employees in the state of California do pay in. And you can get it even if you've been laid off or terminated, as long as you have contributed during a look back period, which is a 1-year period in the past before you apply. And it gives you 60% of your wages for most workers. For the very lowest wage workers, you can get 70% up to a cap. And one really important thing to know about the state disability insurance program is that it is available regardless of immigration status. And there is a 1-week waiting period before your benefits begin, but that period has been waived for folks who've been diagnosed with COVID. All right, and so this just shows you the chart we looked at before, but fills in what we've learned so far, which is that for people who are pregnant or recovering from childbirth, they can get job protected leave, which is called pregnancy disability leave. And during the time they're off work, they can also collect state disability insurance. I hadn't mentioned, but this is important to note that you actually can get up to 52 weeks or a year of state disability insurance if you're eligible, and if you have a doctor certifying that you need it for your own condition. So you'll note that that exceeds the amount of job protection you can get, but that provides some extra cushion in terms of at least money for folks who have a need to take a longer term leave.
Thanks, Sharon. So having covered the ways that somebody can take time off, know their job is safe, and receive income when the reason that they're not able to work is because of their pregnancy or because of those first weeks after somebody's given birth, we want to talk about how you can take time off for the purpose of bonding with a new child. So the California Family Rights Act is a California law that gives employees 12 weeks off where their job is protected. So their employer has to hold their job for them. They can't treat them worse for taking that time off. They can't say no. They can't say it's not a convenient time. They have to let them take up to 12 weeks off for the purpose of bonding with the child. And so because we're talking about pregnancy today and new parents, I'm focusing on the fact that you can use these 12 weeks to bond with a new child, but it can also be used to bond with a newly adopted child or a newly fostered child. And it is available to both parents of that child. And on top of that, it can also be used to take care of a family member who has a serious health condition. So that could be a parent or a spouse or a domestic partner or a child, or just starting in 2021, it could also be used to take care of a grandparent, a grandchild, or a sibling if they have a serious health condition. And so we'll touch on this a little bit later to think about how grandparents can take time off to potentially spend time with a new child. So besides these reasons, so bonding with a new child, taking care of a seriously ill family member, it can also be used for a worker's own serious health condition. It doesn't have to be related to pregnancy, just any serious health condition that prevents them from working. And also to address needs that arise from a family member being deployed who's in the military. So it's 12 weeks within a 1 year. It can be used for any of these purposes. And again, I want to focus on how this time, it doesn't start for the person who gave birth until they've recovered. So until their healthcare provider says, okay, you could go back to work, or you've used up all 4 months of pregnancy disability leave. This time comes after that, whichever of those things happens first. So however, it is important to know that unlike pregnancy disability leave, which we talked about, and pregnancy accommodations, where the only requirement is that your employer has at least 5 employees, there are stricter requirements to take time off under the California Family Rights Act. So the 3 requirements are that you've been working for your employer for at least 1 year, that your employer has at least 5 employees, and that you've worked at least 1,250 hours in the year before your leave, which averages out to about 25 hours per week. And so you'll see that the 5+ employees on the screen is highlighted in red. And the reason for that is that this is a new change in the law. So up until the start of 2021, workers had to have an employer with 20 or more employees to be able to take this time off to bond with a new child. So this change of going from 20 employees to 5 employees is something new and something that some employers might not be aware of yet. So when you're talking with families, it's important to let them know about this. And it can be helpful too to let them know that this is a new change in the law, because there might be times where an employer says no, and it's not because they're trying to violate the law or deny somebody their rights. They might just not know about it, which can create an opportunity to bring in a fact sheet and show the employer and be like, look, apparently this thing exists, and maybe that can resolve the problem. You never know. But it is a new change in the law that it covers people who have an employer with as few as 5 employees. So that's the job protection part, the making sure you have a job to return to. But of course, it's equally important to have a source of income while you are taking that time off from work. So for that, our state has a program called paid family leave. And so when you think about paid family leave, I encourage you to think of it as paid family insurance, because it's not a right to time off from work. It's just a right to income, a lot like state disability insurance. But what it's available for is if somebody is not working because they need to bond with a new child, and again, it can be a newly born child, a newly fostered child, a newly adopted child, or because they're taking care of a seriously ill family member, or they're addressing needs that have arisen because of military deployment, that person can receive 60 or 70% of their regular pay for up to 8 weeks in a year. The qualification for who can get this is the same as with state disability insurance, where if somebody looks at their pay stub and it says CASDI, that means they're paying into this fund so that if they do need to take time off, they can receive income from this fund. Importantly, immigration and citizenship do not impact a person's eligibility for this program. And, we've seen this be an issue that comes up because the applications do ask for a social security number. So there are a lot of undocumented workers who feel uncomfortable applying, but the EDD, the agency that administers these benefits, has communicated, and it's even on their website, that immigration status doesn't matter. So we'll talk a little bit more about that in a few minutes. And so this income from paid family leave, it can be taken all at once, or somebody can split it up throughout the year. So if they want to take 2 weeks here and then 6 weeks later in the year, they can break up their pay in that same way. And again, importantly, it's available to all of the parents of that child, and they can take it at the same time or they can take it at different times, but there's not a limitation on that. The one thing to keep in mind is that it has to be used within 1 year of the birth or the placement of the child. So you can't, take this and save it up and use it much later on. But within that first year, it is something that can be available. And this is a program that we've really been trying to get the word out about too, because we run into a lot of families where they just don't feel like both of the parents can afford to take time off from work, or one of the parents is the main provider and they feel like they can't afford to go without that person's income. Paid family leave helps to fill that gap. It doesn't give 100% of pay, but it does give 60% of pay, with the hope that it will make it more affordable for both parents to take time off and be engaged and learn how to provide care from the start for all of those health benefits that Sharon mentioned at the top. So one of the questions that we receive frequently is, so who can take time off to care for a new child? And like we talked about, the right to take this time off for the purpose of bonding is under the California Family Rights Act. And it's what offers 12 weeks of time to care for a new child. Like we talked about, there are strict requirements to be able to be eligible, which is that 1 year of tenure, 5 or more employees, and 1,250 hours within the last year. But if somebody qualifies, they do get to take all 12 weeks off to bond with a new child. So if the child is healthy, then this time is available to anybody who is a parent of the child. So that can be the biological parents, foster parents, adoptive parents, step parents, legal guardians. If there are other people who are acting as a parent to that child, they can also take this time off. However, if the child has a serious health condition, so let's say it's a child that was born prematurely, the time is available for the parents, but it's also something that can be available for grandparents and siblings. And so that's another thing that changed at the beginning of this year, and we really want to focus on, because we know, babies that are born prematurely and spend time in the NICU, they might require, months and months of having family members there to provide that care. So if mom can take 12 weeks and the other parent can take 12 weeks, that might not be enough time. But it's worth talking to family members and seeing, okay, is there a grandparent who'd be able to potentially step in and provide care? Is there an adult sibling who might be able to provide care? Because now, as of 2021, they might have the right to take time off and know that their job is safe, and to also receive income from paid family leave, so that they're not experiencing a big cut in income in order to be there for the new child that just needs their support. So as far as how to apply for these benefits with the EDD, there is an online portal, which can generally be the quickest way to apply, but there's also a paper application, and that's something that we suggest people who are undocumented use. As far as the timing for applying, people can apply up to 49 days after the start of their leave for disability insurance, or 41 days after for paid family leave. So if somebody, has a baby and they're not able to apply that day, you can wait a little while and then apply. And importantly, if somebody has good cause, so a good reason that they're not able to apply in time, they can still apply later and tell the EDD, like, look, there's this reason I wasn't able to apply at the time, but, I'd still like to receive those benefits. So one of the instances that we've seen come up frequently is if somebody just didn't know that paid family leave existed. They took time off, they had no income. Later on, they learned that paid family leave is a program that's available. We've seen that be successful as a good cause because, it's a pretty good reason not to apply if you don't know that it exists. But if somebody's applying late, we encourage them to include a note explaining all of the reasons that they're applying late. And they're also welcome to give us a call and we can talk through, what some of their options might be for trying to establish that. So one resource I want to highlight for everybody that Legal Aid at Work has created is a guide for undocumented workers on how they can apply for disability insurance and paid family leave. So as I mentioned, the application does ask for a social security number, which can make it scary and seem, inaccessible to some workers. But we've talked with the EDD, we've worked with the Labor Workforce Development Agency on coming up with steps that somebody can take so that they can apply and they can receive these benefits, whether or not they are a citizen. And so it involves asking for a paper application and then, leaving some things blank and including information that the EDD needs, like including work history and showing pay stubs of what income it is that somebody has paid into the system and what those steps look like. So this guide, which is available on our website, it goes through step by step what you need to do, what you can expect, what information they need. And we found it to be a really helpful resource in figuring that out because like we talked about, every worker, for the most part, they pay into this fund out of their paycheck, whether somebody is documented or not. And if you've been paying into this fund throughout your entire career and an occasion comes up when you can't work because of your health or your family member's health, you should be able to get that money back because you've been funding it, and it can be such an important resource during those times. So going back to this chart that we started with, we have now looked at kind of those four main protections and benefits. So some of these rights, like we said, give people the right to take time off, to know their job is safe. Others give somebody the right to receive income. So for pregnancy, it's job protection through pregnancy disability leave, which somebody requests from their employer. For money, they need to apply for state disability insurance, which they apply through the EDD. And then for bonding, somebody would request California Family Rights Act time. And so that's something they'd need to talk to their employer about. And for paid family leave, they'd need to apply to the EDD. And I know it's more confusing than it should be, but we just really want to highlight these different steps because otherwise we pretty frequently hear from folks who they took time off, they applied for paid family leave, they received paid family leave, and because the state was paying them, they assumed that their time off from work was state sanctioned and it was fine. But unless they qualified for the California Family Rights Act and talked to their employer about it, their job might not actually be there for them when they want to return. And at the same time, we hear from lots of folks who take time off because they need to when they have a new child, but they don't realize that there's a way that they can get income throughout that time. And they struggle without having an income when there's not a need for them to do that. So we have this chart just to make sure we always keep these things in mind. So there's the question of rights for pregnancy, rights for bonding, and then how do you make sure that job is safe, and how do you make sure that you get paid. And with that, I'm going to pass it back to Sharon.
Great. So that has been a lot of information. And so we want to show you this chart that really kind of depicts what how this would work in practice for a pregnant person who is able to access all of the rights we've talked about. So they're eligible for the job protection laws, they're eligible for the wage replacement. So how does it all fit together? And you'll see that on this timeline, on the top, we show the money, the wage replacement. On the bottom is the job protection. And you'll see right kind of towards the left, a little bit in there, under that first category, you have the birth. So it shows that's where the person gives birth. But starting 4 weeks prior to the due date, starting first at the top line for wage replacement, that's when, as soon as their first day off of work, basically the first day of their leave, they can make their application for state disability insurance. And unfortunately, you cannot apply early. You're really supposed to apply once you are actually disabled by pregnancy, according to your healthcare provider. So this is showing a normal, quote unquote, normal pregnancy, uncomplicated pregnancy and delivery. So the person would apply for benefits starting 4 weeks before the due date, and they would serve a 1 week unpaid waiting period, meaning that they will not get wage replacement benefits for the first 7 days from the state, from the Employment Development Department. However, they could apply their accrued paid sick leave, for example, during that time from their job. And so after they serve the waiting period, then they can get 9 weeks of benefits from the state for the time that they are actually disabled by pregnancy and childbirth. So that would be 1 week waiting period plus 3 weeks. That equals the prepartum, pre-birth period, 4 weeks before, and then 6 more weeks to recover, assuming this is a vaginal delivery. It would be 8 weeks to recover if it was a C-section. So that is the state disability insurance piece. And because the Employment Development Department is the agency that administers state disability insurance, and they also administer paid family leave, they helpfully will know that when you're coming to the end of your state disability insurance for pregnancy and childbirth, they will know that you are now going to be eligible to apply for paid family leave. So they will actually send you a notice and an application like, okay, are you recovered? Now it's time to get your benefits for paid family leave. So they make it pretty easy for the pregnant parent to get paid family leave, and it's fairly streamlined. And then they can get 8 more weeks, right? Once they've recovered from childbirth, that's when they can get 8 more weeks of benefits at the same rate, either 60 or 70% based on their income, to bond with their child. And then looking now to the bottom of this chart, that shows job protection. So for the same period that the person is getting and has applied for state disability insurance, so that 4 weeks before through 6 weeks after childbirth, their job is protected under the Pregnancy Disability Leave Law. And remember that that law applies to everyone who works for an employer with 5 or more employees, regardless of how long they've worked there, regardless of how many hours a week they work. So, so that is what's protecting your job. That law is protecting your job. It also is requiring the employer to continue your health benefits. And then once that person has recovered from childbirth-related disability at the 6 weeks postpartum point, then they can, if they're eligible, begin their 12 weeks to bond with the new child. And as Katie had mentioned, there are some more strict eligibility requirements for that law. So not everyone who's going to be eligible for the first chunk of leave shown on this chart, the first 10 weeks, will be eligible for the next 12 weeks of job protection. So this is where it can get confusing. Thankfully, because of the new law that Katie mentioned, that we and our partners across the state worked on to expand access to job protected bonding leave and other forms of leave under the California Family Rights Act, many millions more workers are now eligible to take bonding leave than used to be eligible. And so that would cover folks who've worked for employers for 1 year, who have worked a certain number of hours on the job in the past year, and who work for employers with 5 or more employees. So, and then you would get 12 weeks to bond, but importantly, you can take those 12 weeks anytime before the baby turns 1, or if it's an adopted or foster child, within a year of placement in the home. Now, if the person is not eligible for California Family Rights Act leave, but they have paid in to state disability insurance, they can still get their paid family leave benefits, but their job will not be secure. So we would recommend folks, can call our helpline and we can walk them through suggestions for how to address a situation like that. Often we'll recommend that, someone might want to ask their employer, look, I'm not asking you to pay me for this time. I'm entitled to this pay from the state. So I'd like to take the 8 weeks of paid family leave. Will you hold my job for me? And if they say yes, try to document that in writing. It's not as secure as having the law protect their job, but it might offer some measure of protection. So, so that's how all of this works for the pregnant person. And then this chart shows how it all works for someone who is not the person who gives birth. So a parent who does not give birth, or also for someone who's caring, who's taking leave to care for a family member who is seriously ill. So, so for this would apply to all parents who don't give birth, so dads, parents of all genders, adopted foster parents. So you'll see here that this chart does not show the pregnancy disability leave or state disability insurance piece, because this is a parent who did not give birth, and so there is no pregnancy related disability or childbirth related disability. And so the timeline basically starts at the birth, or if we're talking about caregiving leave at the beginning or the onset of the illness that requires the employee's care. And so on the top, you'll see that the person is entitled to 8 weeks of paid family leave per year at 60 or 70% of their wages. And then on the bottom, they get the 12 weeks for bonding. That would be, if it's bonding, it's within 1 year, or for caring for a seriously ill family member, which an employee can get 12 weeks every year, as long as they're eligible. And those same eligibility requirements that we talked about before: 1 year on the job, 1,250 hours, and 5 employees would apply for this kind of leave. I see a question about information for self-employed people. That's a really, really good question. And I have to say, when we talk about self-employed people, one thing that I always like to clarify at the top is that lots of folks may have the title of a contractor or an independent contractor, and it's important to know whether they are under the law truly an independent contractor or a self-employed person versus someone who's been misclassified as an independent contractor, but really they are considered under the law an employee. The job protection laws that we've talked about and the wage replacement leave laws that we've talked about apply to employees, but they do apply to people who've been misclassified as independent contractors, but really should be classified as employees. And so if people have questions about, am I really a contractor or am I an employee? They can call our helpline and we can walk them through the test to under the law to determine whether you're a true contractor or an employee. And there's actually some additional steps to take when we're talking about applying for benefits with the EDD, the Employment Development Department, if you have been misclassified, to let them know that you believe you've been misclassified, and so that they can credit you with the wages, because many people who've been misclassified, basically that means they're not contributing to the state disability insurance program. And therefore the agency will say, oh, I don't have any wages that show up here or any contributions to the program, and so you're not eligible. But there are steps you can take, and we can walk folks through that to explain to the agency that actually you should have been allowed to contribute, and therefore you should be eligible for these benefits. But that being said, there are, of course, some actual true contractors and self-employed individuals. And there is a separate program that the Employment Development Department runs for true self-employed individuals to get access to paid family leave and state disability insurance. And that is called Disability Insurance Elective Coverage. And it has its own eligibility criteria, so we won't get into all the specifics of that today, but you can feel free to call our helpline or get in touch with us after if you have more questions about that. It is a little bit complicated.
Thanks. And so this ties into as well the question Anibal asked if somebody hasn't paid in. And so as Sharon mentioned, there's a way that you can provide that information to the EDD so they can look into it and see if you should have been, and if it's on your employer that that information wasn't provided. And so that's something that's covered in our undocumented worker toolkit as well. Like, if you've been just being paid by checks or cash, like what is it that you can do to apply and to show the EDD that you were an employee and you were earning income and that you do qualify for those benefits. And so now we've covered the main rights to time off and to pay, but I'm going to go through a few more important rights for new parents, and then I'm going to pass it to Sharon, who's going to speak a little bit about some COVID-19 specific protections that are worth knowing about as well. So people who have children and give birth in California have the right to lactation accommodations. And so that's the right to take the amount of time that they need in order to pump or breastfeed at work. And then the second is to have a space to do that. And so these two requirements of having a private space and having adequate time, they have been around for a while, but it was just starting in 2020 that California passed a new protection that got a little more detailed about what that space could be. Because we were hearing from people who were being told to pump in supply closets or refrigerated spaces and spaces that were technically private, but not at all suitable for pumping milk. But starting in 2020, employers were also required to provide a space that makes sure it's not a bathroom. So that's an old requirement. That one has been around, but also that it has a place to put a pump, like a surface, that it has a place to sit, that it has access to electricity, and that it has access to refrigeration and running water somewhere nearby. So those are things that an employer needs to provide. There are some exemptions for smaller employers if they're not able to provide one of those things. But it's important to remember that, if they can't provide access to running water, it's just not possible. That doesn't mean that they don't have to provide all of these other requirements. So employers are required to do what they can to make sure that somebody has a safe and adequate place to pump milk while they are working. And one of the other requirements of it is that employers actually have to have a lactation policy. So for new parents, we recommend that, they ask their employer about their lactation policy sometime before they come back from work, because their employers are required to have something in place. They're also required to share it with employees when they ask about leave. But, if their employer hasn't shared it, it's a good thing to ask about beforehand. So you can have that set up instead of have someone come back to work and on that first day back realize their employer hasn't considered it and that they don't have a place to pump. And the thought behind requiring them to have the policy is just to take some of the pressure off the parent. So it's not their job to educate their employer about what pumping milk requires and what lactation is. The employer is supposed to have a policy ready on that topic. But another important protection for parents, and this is one for those who have new children as well as older children, is the Family School Partnership Act. And it's a law that allows folks to take time off from work and to know that their job will be safe if they need to be engaged in childcare or school activities. So it could be, going on a field trip or going to a parent-teacher conference. Also to search for or enroll a child in care, so looking for that new school or daycare. And then very importantly this year, to take time off because of an emergency. So if a school is closed because of smoke or fire risk or because of COVID-19, somebody can use this time to care for their child and deal with the emergency and know that their job will be safe. It is limited to 40 hours in a year and 8 hours in a month, except for in a circumstance where it is an emergency. So importantly, this isn't the right to be paid while you take this time off. So an employer can say, okay, you can take the time, but we're not going to pay you. But they're not allowed to hold it against the parent. They have to let them take the time. They can't give them points for it or offer discipline. It's just a protection to make sure that parents are able to be involved in their children's schooling and daycare in the ways that they need to without being punished for it. And with that, I'm going to pass it back to Sharon.
Great. So I just want to touch briefly on paid sick days, which has, of course, become a very, very important topic over the course of the pandemic. We were not well prepared for this pandemic in terms of access to paid sick leave. There is no federal right to paid sick leave. In California, we only have the right to 3 days, basically, although some localities do provide more. But in terms of California's paid sick leave law, it provides time off for your own illness, for preventative care, to go to an appointment, or for taking care of family. And essentially, you accrue 1 hour of paid sick leave for every 30 hours worked. And you can use this leave after you've been on the job for 90 days. An employer is allowed to cap it at 3 days or 24 hours per year. And it's important to know that you may be entitled to more leave under local laws. You should request this leave from your employer. And this is one of the laws that actually provides both pay and job protection. So for these paid sick days, your employer has to hold your job. They can't retaliate against you for taking it, and they have to pay you your regular rate of pay. And then we also were able to enact some supplemental COVID-related but temporary paid sick leave. There was a law that was similar to this last year, but it expired at the end of the year, and the legislature enacted another version of this law that is still temporary but goes until the end of September. And stay tuned, maybe there'll be an extension. It seems like we really are going to need one, unfortunately. But this law provides paid sick leave that is also job protected for 80 hours. And it is available for a variety of COVID-related reasons. It can be used if you've been exposed to, diagnosed with, have symptoms of, and you're seeking a diagnosis of COVID-19. It also can be used to care for a family member who has COVID or who's been advised to quarantine. It can be used to care for a child whose school or regular care is closed or unavailable because there's been COVID-19 on the premises. And very importantly, it can be used to get the vaccine and to recover from side effects of the vaccine. Next slide, please. And so this law is not available to everybody. It's available to people who work for employers in California with more than 25 employees. So 26 employees and up. If that's the number of employees that are employed by your employer, you can get this leave. So it's 80 hours or 2 weeks. It's retroactive, meaning it was enacted in March, but basically if you had taken, as I mentioned, the prior version of this leave law expired at the end of the year. So if you needed leave for one of the reasons that we've just talked about between January and March of 2021, and you took leave that was unpaid, you can now ask your employer to pay you for that time under this law. If you did take leave for COVID-related reasons in 2020, then you can still qualify this year under this law. And this leave, importantly, is in addition to the paid sick days that we just talked about under the permanent California paid sick days law. So you could actually get 80 hours or 2 weeks under the COVID law, and then 3 more days or more, depending on your local law, separately. And this is a leave law that you request from your employer, and it provides both job protection and pay. We actually have a sample letter requesting COVID paid sick leave on our website that can be helpful for folks.
Thanks. And I know we've covered a lot, and that's why I wanted to make sure we also share some resources on these topics. So if you have not memorized each of these things as we've spoken, it's okay. We have guides and cheat sheets that explain what these protections are, who qualifies for them, and how to access them. So one of them is we've created this colorful pregnancy plus my job roadmap. And working on this one, we consulted with folks who have expertise. This guide just takes you through, if somebody's pregnant, what are the first steps that they need to take in relation to their job? As they go through their pregnancy, what do they need to be telling their employer and what rights are available to them? And it's available in English and Spanish and Chinese. And then to the side, we have a guide for both parents. There's one side for I'm pregnant, one side for all other parents, going through these protections that we talked about. So making sure that someone can take time off to bond, that their job is safe, and that they can get paid, and that they don't miss out on any of these important benefits and lose their job or spend time going without income when they really don't need to be. And then on the COVID-19 front, we've also created some resources that explain these rights and protections in the same way. So just as Sharon talked about how COVID-19 supplemental paid sick leave is a critical protection that gives folks 2 weeks off, that law expires at the end of September, and it only covers people who have employers with 26 or more employees. So because of that, there are other protections like the ones we talked about earlier for your own serious health condition or for taking care of sick family members, like the California Family Rights Act and paid family leave, that are important. So what this does is it goes into those scenarios to help you identify if somebody has COVID-19 or if they're taking care of a seriously ill family member, which of these protections apply and when, and how you can make sure that you access them, so that folks don't have to worry about losing their job or going without income or trying to decide whether or not they can stay home when their healthcare provider has said that that's what they need to do for their health. So it has this guide, it has sample scenarios, frequently asked questions, and then also sample requests to your employer for that time off at the end. And then finally, there's more available on our website. And we do have that work and family helpline that we mentioned, where if anybody has questions for themselves from, I need time off from work, or, how long can I take? I talked to my employer and I'm not totally sure. Or, how is it that I get income during this time? They can call us and they'll reach a voicemail, and then somebody from our office will call them back within the next generally 1 or 2 business days to talk with them about their situation and provide advice. And this is also available for people who are working as advocates or healthcare providers for families. You can call with questions and we're happy to provide advice about how you can support them in making sure they get the certifications that they need so that they get that income and their jobs are safe. And also, of course, just feel free to reach out to Sharon or I. So we also have our email addresses here. And fortunately, we do have some time for questions. So if anybody else has any questions that they'd like to ask, feel free to put them in the chat and we're happy to address them. So I don't see any questions coming up, but in the meantime, I thought, Sharon, I can ask you a question that we get pretty often. And in the meantime, people can think of what questions they have. So under what circumstances can grandparents take time off to care for a new baby, and how can they get support through that?
Yeah, so this is a great question, and the answer fortunately has changed for the better recently as a result of the expansion to the California Family Rights Act to cover more family members. So grandparents who are employed as employees and work for employers with 5 or more employees and have been on the job for a year and have worked a certain number of hours can take leave to care for their grandchildren who have a serious illness. So for example, if a baby is in the NICU, as Katie had mentioned, and both parents are have exhausted their leave or unable to take more leave, a grandparent will be eligible to take their own leave to care for their grandchild. And if they've paid in to state disability insurance, then they can get 8 weeks of partial pay through paid family leave. So they would get, if we kind of think back to the chart that we showed you of the caregiving chart, that's what it would look like for the grandparent. They would get 12 weeks of job protected leave under the California Family Rights Act, and for 8 of those weeks, they could get paid family leave while they take care of their seriously ill grandchild. And then also importantly, employees can take leave to care for their seriously ill grandparents. So if you have a grandparent who is dealing with a serious health condition and needs your care, you now are able to take both job protected and partially paid leave to care for your grandparent.
Thanks, Sharon. And so for a grandchild that's healthy, are there any circumstances where a grandparent can take time off to care for them?
For a grandchild that is healthy, are there instances where the grandparent can take time off to care for them? Let me think about that. Do you want to answer that one, Katie?
Sure.
Answer your own question.
So as we talked about, if there's no health issues, it's the parents who can take time off to bond with a new child, but that's parents who are also adoptive parents and foster parents. So if grandma or grandpa, they're the one who's adopting or fostering the child for a time, they can take that time off. And there's also, it's a Latin term, which is not helpful, but something called in loco parentis, which just means like if you are acting as the parent, that you have those rights to time off. So it's not something that's the most straightforward, but if, grandma really is the one who's taking care of the child and providing financial support and the one who's being there might be a way that she can take time off and have her job be safe. But if somebody's in that circumstance, they should feel free to call us and we can help them figure out, whether they can take that time off and what it would look like.
Katie, let me ask you a question. So if someone has a very high risk pregnancy and they are, and then they have complications after childbirth. What is the maximum amount of time someone can take with job protection and wage replacement under California law?
That's a great question. So as we talked about earlier, there is that law called pregnancy disability leave, and that lets someone take time off when they are disabled by their pregnancy. And so, it doesn't have to mean they're disabled from doing everything. It doesn't mean they have to be on bed rest, but just they can't perform their specific job. So that can cover them for 4 months and make sure that their job is safe. After those 4 months, if they still cannot work because of their health, if they qualify for the California Family Rights Act, their employer can start counting that time. So those 12 weeks that could be used to bond, some of that time could be used for the employee's own health, and making it a total of 4 months plus 12 weeks. And after that, it's worth knowing there are some general protections for people who have disabilities. So if somebody runs out of that time, they shouldn't give up. It gets a little less clear. There's no 100% guarantee that their employer has to hold their job, but it becomes more of a balancing test where the employer has to hold it unless they can show that it's really hard to do that. So that can be a great time to give us a call and talk with your healthcare provider to make sure that you do what you can to keep your job safe. And like we talked about, state disability insurance, fortunately, it can go for up to 52 weeks. So someone can receive income that whole time if they continue to be disabled during that. And so I see a question came up, which is, so can someone take paid family leave to care for an adult disabled person who is their child? Do you want to take that one, Sharon?
Sure. Yeah, this is a really, really good question. And the answer is yes. And really, it would depend on the same concept of in loco parentis that Katie mentioned. So if they are acting as a parent to an adult person with a disability, then they can take leave to care for that person under these laws. And in fact, we were just working on a case recently that addresses this question, where an employee was taking leave to care for his sister, who was an adult with schizophrenia, and he acts as a parent to his sister, and so is entitled to leave to care for her under these laws. Thanks for that question.
And so we've got one more, which is, are employees required to use all of their accrued sick leave first before getting paid leave with any of these laws and protection? So I'll pass that back to you.
Great question. So really the way that the job protection laws work is that if you have a qualifying reason for the leave, like you have a serious health condition or you're caring for someone with a serious health condition, then your employer needs to hold your job if you meet the criteria to be eligible. So they need to protect your job for it. They can't say, first you need to take your paid sick leave and then we'll talk about job protection. They really need to protect your job while you are on leave for a qualifying reason. There are some specific rules about circumstances in which the employer can force you to draw down your accrued pay. And so there are circumstances when, while you're on that leave, so while you're on California Family Rights Act leave, for example, or pregnancy disability leave, your employer can require you to use your sick leave, your accrued sick leave during that leave. The rules get a little bit different when we're talking about vacation pay, and depending on the circumstance of the leave, if you're taking leave, for example, not because you're sick, but because you're bonding with a new child, then that's a circumstance where the employer cannot require you to use your sick leave, but might be able to require you to use your accrued vacation pay. So it does get a little tricky. And I will say that if you are receiving state disability insurance and or paid family leave from the state, then the employer is not allowed to require you to draw down your accrued pay. It's only if the leave is like otherwise unpaid can they require you to draw it down. So I know that's a little complicated, but if you have specific questions about that, we can kind of walk you through it if you want to call our helpline about like a particular scenario. And Katie, feel free to clarify if you want to add anything.
And I'm glad you brought that up about the question of like how paid family leave and state disability insurance work with your own sick time. So one thing that you can do if you want is you can request your employer to coordinate your paid sick days with that time that you're receiving state disability insurance. So like we talked about, state disability insurance provides 60% of pay. Some employers are willing to let you use like 40% of a paid sick day, you know, for each of those days to get up to a total of 100% of your pay. So that can be a way to make sure that you still get your full income. But it's important to flag that the reason it's that 40% on top is that you're not allowed to get over 100% of your pay. State disability insurance is designed, and paid family leave too, where they're available if you're losing out on income. So if your employer is paying you 100% of your pay, you're not losing out on income, and you're not going to be able to qualify for paid family leave or state disability insurance. But, you know, if coordination between those two is something you're interested in, it's always good to talk to your employer about it. All right, do we have any other questions?
Okay, last call for questions. Please put them in the chat.
Everybody, we're so appreciative of you being here, Katie and Sharon. This has just been great. And if there are any other questions, and people have your phone number now so they can refer people to you or call themselves with questions. Looks like there may be another question.
Yeah, one more question. It looks like from Carmen.
Yeah. So Katie, I can read this one, and maybe if you want to answer it. So can
Sure.
pregnancy leave be more than 4 months if a doctor certifies that the woman is disabled due to pregnancy complications? Can employers require patients to take their vacation sick time prior to using paid family leave?
That's a great question. So if that circumstance comes up, I suggest giving us a call just so we can go into that person's specific circumstances. So it's like 4 months is like guaranteed. If you qualify, your employer has to hold your job. They have to act like you never took that time off. You know, they have to treat you the same as if you were working during that entire period. But if someone needs more than that, they can start counting into those 12 California Family Rights Act weeks. Or if somebody doesn't qualify for the California Family Rights Act, there are some just general protections for people who have disabilities. So I know it's not a clear answer, but basically there's not any point where like you get beyond these dates and you have no protection and your job has no obligation to hold your position. Instead, it gets into a little bit more of a fuzzy territory where it's important to talk with the healthcare provider about, you know, exactly how much time you need and think about what your medical note is going to say, because it gets into that balancing act space where the employer has to hold your job unless they can show that it's way too difficult to do that. So, you know, for instance, if you give your doctor a note that says, okay, you need 6 months off, it might be your employer might have an easier time showing that that's really hard, as opposed to if, you know, your healthcare provider gives you a note saying, okay, you need 1 month off. And, you know, 1 additional month, it might not be that hard, and you can always have it extended if it comes to that. So feel free to reach out. And I think Sharon addressed a little bit about the pay and sick days and vacation beforehand. So feel free to clarify that, Sharon, or that's something people can reach out for.
Yeah, well, there is a sort of an odd rule in the paid family leave law that you might be referring to, which allows employers to say that an employee has to use 2 weeks of their accrued vacation before they can use paid family leave. A lot of employers don't know about that or don't insist on that, but it is there. So it's possible an employer could require someone to use their vacation, 2 weeks of vacation, they can't allow you to use your sick time before you can use paid family leave. And then I see there's a couple more questions have come in. Vina asked, is there a specific letter you have online for those who have high risk for COVID so that they can have assistance if they're asking for accommodations at work? We do have a number of letters on our website for folks who are requesting disability related accommodations. This is one where it might be worth having someone call our helpline so we can, walk them through exactly what they would want to include in that letter based on their circumstances. Some people, for example, qualify for leave because of their own disability, in which case we might want to frame the letter based on their disability. Let's see. And then I see Dina asked a question about coming back from international travel. Do we have to quarantine? I think that would actually be more a question for, to look at like what the public health orders are or what, your individual employer requires in terms of safety precautions. Katie, I don't know if you have anything to add.
The only thing I wanted to add just to Vina is feel free to send us an email and we can send you those links. That question was Dina. So we had a question from Vina and then Dina. But Vina, for the healthcare provider letters, you can send us an email and we're happy to send you specific links and keep talking about that. So thank you everybody for the great questions and participation today.
Thank you, Katie and Sharon, so much for this. We really appreciate it so much. We appreciate all of the participation, people putting their questions and comments in. And as usual, I want to remind you to complete your evaluation that will be sent to the email that you use to register for the training. We really appreciate it. And you will be able to find the recording of this training on First 5 Alameda County YouTube channel. And all our other trainings are on there as well. So hope to see you all again soon.